When there's a dispute at work over salary, wages, or overtime, employees sometimes lose the money they earn simply because they don't understand their rights. Let's talk about some of the common questions that arise when an employee files a wage and hour claim against their employer. The Fair Labor Standards Act, or FLSA, establishes the minimum wage and overtime pay requirements for employers within the United States. Unfortunately, employers across the country sometimes fail to pay their employees the wages owed under the FLSA. There are distinctions between hourly employees, those who work for an hourly wage, and salaried employees, those who work for a monthly or yearly wage. Both of these types of employees may be entitled to overtime and minimum wage under the FLSA. For an hourly employee, the FLSA entitles you to a standard minimum wage and overtime pay for any work over 40 hours in a single work week. If you are a salaried employee, you may be entitled to a minimum wage and overtime if you do not meet one of the exemptions listed in the FLSA or other federal law. At John Bales Attorneys, we may be able to help you determine if you are entitled to overtime under the FLSA. Under the FLSA, employers are not allowed to fire or discriminate against employees who file a wage and hour claim. The law protects against termination, harassment, or other forms of employer retaliation. If you've been underpaid at your job, contact us immediately. We work to protect the rights of Florida workers by holding employers to their commitments. Employment law can be complicated. Don't take a chance of losing the wages you earned. Contact John Bales Attorneys today.